tort law claim would not be allowed to proceed.
Counsel, that's sort of turning things on its head. Preemption on its head. It's like Congress has to act to overturn our presumption. But why did we have Boyle at all? You say this is based on some exclusive Article I power. The power to raise and support an army includes training an army. It's exclusive to the federal government. States can have militias, but not army. So why did we bother with Boyle at all?
Because
you're sort of saying, you're going a step further and saying that the war power is somehow more important than the power to support and raise an army, correct?
So certainly when you're talking about combat operations on a foreign battlefield, that's different. And I think maybe why.
But then why did the military issue its regulation? They're a military contractor, asked for indemnification, and the military said no, because under Boyle, if you're making a judgment contrary to our directives, you're liable. And we don't see why you should be indemnified. The government, and that was in the middle of the Iraq and Afghanistan war. It was a wartime regulation that they were considering under a Republican president, 2008, under President Bush. And they're saying, no, in a time of war, we're telling you you're responsible. You said earlier that we should leave this to military judgment. So why shouldn't we leave this, a field preemption that's contrary to two Supreme Court precedents, Little and Mitchell, that never thought there was a wartime exemption for anyone, 1801, 1857, certainly closer to the revolution than now, to our founding. Where are we going? Why aren't we leaving this to the parties who should decide this?
So if I can start, I think,
Congress and the military. The military could write its contracts more specifically to indemnify or direct.
I mean, you'll hear from the government shortly, but I'll point out the government has consistently maintained the position it does now since at least 2012, that claims asserted against a contractor for combat operations on a foreign battlefield are preempted. They are not covered by the discussion in the 2008 regulation. That's their position. I mean, the broader point that you raised, and I think this goes back to Justice Kavanaugh's talk about what should be the default rule and why couldn't Congress, if they want to provide relief for contractors here, speak clearly. That's an argument that is made and could be made in almost every case for implied preemption. Chief Justice Marshall acknowledged and rejected that argument in Osborne. Justice Kavanaugh quoted the language from Crosby that says, that Congress, the fact that they didn't expressly preempt something just maybe show that they understand implied preemption. I think the default
After
rule—
Boyle, why would they understand that?
So after Boyle, they would have understood that the way the court interpreted and provide preemption to a contractor based on a FTCA exemption, they reasonably could have understood that courts could hold, as all of them have, that there is preemption for combatant activities.
Yeah, but all of the exemptions that have been created by the circuits all involve, to some extent, military directions that are that have specified in some form the directive the contractor followed.
I would disagree with that. I think the majority of the courts don't go that way.
No, the Fourth Circuit is broader. Thank you.